Good afternoon, everyone. Welcome to the Appellate Division First Department. We have our arguments for today, October 28th. Before I start the calendar, I just wanted to acknowledge that over the weekend, one of our colleagues, John W. Sweeney, passed away. Many of you may remember Judge Sweeney. He was an integral part of this bench. He was a friend as well as a colleague, and we are certainly going to miss him. So I'm going to call the calendar now. Please keep in mind that we have read your briefs. We are fully familiar with your arguments. Please only ask for the time that you actually need to get out the salient points of your arguments. People v. Antoine Brown. That matter is submitted. Akande v. the City of New York. Appellant. I think we're good. That matter is submitted. Thank you. Matter of D. Children. That matter is submitted. Molnar v. Molnar. Appellant.
Requests 4 minutes and 2 minutes to vote.
Respondent.
I'm happy with 4 minutes as well.
4 and 2 and 4. Myers v. Doherty. Appellant. 5, 2 and 5. 242 10th Investors v. GVC 242 10th sponsor. Six, 2, 5. People v. Timothy Nesbith. Yeah, who are you? I'm for the appellant, Your Honor. So yes, I was going to say, can we submit? That's fine. Thank you both. That matter is submitted. Roger v. U.S. Bank Trust. Appellant. There's no appellant. Did you wish to submit or did you wish to argue? That matter is submitted. Thank you so much. Montegieri v. Apis Capital. Respondent? Respondent requests 7 minutes. 626. People v. Isaiah Felix. 5, 2 and 5. Rhea Realty v. 18 East 69th Street tenant. Respondent? 625. Matter of Brianna. Matter is submitted. United Legwear v. All in the Cards. Appellant? Five, 2, 5. People v. Maurice Reed. That matter is submitted. Splain v. New Gold Equities. 425. Alvarez v. 471 West 144.
Appellate, Your Honor, requesting 5 and 2.
5, 2 and 3. Fishman v. Bunty and Joti.
Thank you, Your Honor. Appellant requests 5 and 2.
525. People v. Philippe Solar. Matter is submitted. LaRue v. 1201-31 Lafayette. That matter is submitted. First case for argument is Molnar v. Molnar. Yes, you may proceed.
Good afternoon, Your Honors. May it please the court. My name is Robert Michaels, and I represent the defendant appellant. We've brought this appeal before this court because we believe that the order that was made by the lower court was unfair and inequitable in that it directed an affirmative obligation on the defendant appellant to pay 100% of the college education expenses for the twin boys who were beginning college, which he was forced to take with Student Plus loans.
What was the original order? What did the original order state in terms of breakdown?
Required the respondent plaintiff to pay 100% of the private education expenses for the children.
Did the mother consent to pay the tuition?
The parties had an informal agreement starting in 2019. So this tortured history was that a year after they made a full financial settlement in 2014, the father stopped paying his financial obligations. The mother moved to compel, the father moved to modify. Those financial obligations.
But I'm sorry, is the answer yes?
The answer would be yes. So,
I'm sorry, what was the response?
excuse me?
Was the answer yes?
I'm going to have to ask that you repeat the question, Your Honor.
Did the mother consent to pay 100% of the tuition?
Yes, under an agreement that she would be paying for the boys' expenses as of 2019, and the father would be paying for the girls' expenses.
And how did that detract from what the court ultimately ordered in this case?
In this case, the court directed that the mother and father share the expenses 50-50, but have the mother pay the college expenses for the boys entirely for the year, claiming that she consented to do so, which she didn't. She did so under an informal agreement. And at a time where the younger daughter was in a therapeutic school, which I'm happy to inform
So there's
the
a
court.
portion of the order that was granted on consent of your client, correct?
It was not granted on consent, Your Honor.
Oh, okay.
It was my client operating under the assumption that the father would continue to pay for the daughter's expenses. The two daughters made arrangements for student loans and obligated herself to pay for the boys.
What was the basis for this request? Were there any additional financials which were submitted or any other information submitted to the court regarding the necessity for the mother to now pick up the additional obligations?
Absolutely none. As a matter of fact, it was a defective application because the father made an application and did not submit any financial information, did not submit a current net worth statement under 202.16 of the rules. He merely said, the daughter is in a therapeutic school, it's costing $20,000 per month. As we pointed out to the court, one of the sons had been in a therapeutic boarding school before this, and the mother, through her parents, had taken loans to pay entirely when the father had a 100% obligation to pay for it. So this is unique in that the court imposed a financial obligation upon the defendant mother when the court had denied the defendant mother's application to enforce the obligations against the father pending a hearing. And what we asked the court to do was refer the issue of the allocation of expenses to the hearing that the court had ordered.
Thank you.
Good afternoon. I'm David Molnar. I represent myself. The missing context here is that all of this is based on my 2015 application for downward modification under Domestic Relations Law 236B9, which has dragged out now for over a decade.
Did you submit a recent net worth statement?
I have submitted two since the application was submitted. I submitted one.
What year did you submit those? What years were they for?
So the first time I did it was in 2015 when I filed the original application. It was found that I had made a prima facie showing. It was referred to the special referee. We had a separate requirement before that appearance. I filed an updated
But
statement.
as to the statement of net worth, you filed two. One is from 2000, what, 15?
2015, again in
What's- and what about
2018.
the second one?
The second one was 2018, June.
When you appeared before the court, what year was that?
When I appeared before the special referee, or on this that's being appealed
Yes.
from. That was 23, but there was also a forensic audit that I submitted to voluntarily.
Did you submit a statement of net worth for that year?
I did not, and I maintain I'm not required to.
So, Mr. Mona, let me just make sure that I understand. You had statement of net worths for 2015, 2018, and now we're in the year of 2023. And it's your contention that in 2023, you don't provide any information about where your finances are in 2023, but you want the court to rely on 2015 and 2018 for a financial position in 2023.
It's a request for payment of extraordinary expenses that had reached $500,000. We've had a dozen disputes over things that are a 30th or a 40th of those
But
numbers.
so I just want to be clear, though, I know my colleagues stated 2023, but we were talking about tuition for 2024 and the year 2024 to 2025 for expenses, for educational expenses.
Correct.
Is that
but-
correct? So how would your finances in 2018 guide the court in terms of making a determination as to who should bear the responsibility of the tuition for 2024, 2025?
The matrimonial court has a mountain of financial disclosure for me. I went through an 8-month voluntary forensic audit.
When was that?
That was 2019.
Okay, so again, I mean, things change, you know, the economy changes, your position changes in terms of your finances. I'm just trying to, how do we know, or how would the court be able to determine exactly what the change in circumstance was in relation to 2024, when the last financials you submitted were in 2018?
We're up to motion sequence 70 in that case, in 12 years. If you look at the docket, there's lots of financial information that I have disclosed. So I would maintain that the court was in a position to know that I was borrowing money to address the emergency needs of my self-harming daughter with suicidal ideation, and the mother did not contribute $1, but she has plenty of money to pay Mr. Michaels. If the court had asked me for further financial disclosure, I would have given it, but I've spent 10 years doing nothing but making
But
financial
the
disclosure.
court not only would have had your financial records, but did the court not also need the mother's financial records as well?
You'd have to ask the court. What I'm saying is, from my point of view, they are steeped in the financial situation of the parties at this point, and that's why they didn't even address it in the other. And when I read the statute doesn't say that it's a serial obligation. We are within interim relief after interim relief after interim relief. Everything is subject to reallocation. On that basis, if they make a mistake, it will be adjusted when the matter is decided on the merits after the hearing before the special referee.
Thank you.
Your Honors, just to
I'm sorry, Mr. Molnar, there's rebuttal by your friend on the other side. So did the mother submit, did your client submit any financials, or was requested to submit any
The only
current
thing-
financials?
My client did not submit any financials with regard to her own financials, because the duty is upon the movement to submit a current and accurate net worth statement and financial information. What we did submit to the court, and it's found in the record at page 115 and 116 and 152 to 176, is proof that in the year prior to this application in 2024, Mr. Molnar received cash flows from 2 entities that he does work with in excess of $1 million.
So was that a part of the record?
It is part of the record. And that was the only financial disclosure of any kind in the record. And when Mr. Molnar says that this has a long history, the court had it right. Motion sequence 52, which is not part of the record, was the same application by Mr. Molnar. It was denied and referred to the special referee, who is now getting the matter back after the court reversed the referee that found no substantial change of financial circumstances. So the only reason that hearing is not going forward is because, as Mr. Molnar says, we're at motion sequence 70, because he continues to file motions, and just did one yesterday, asking for more discovery. This is never ending. It has to go to a hearing, and that's where the information concerning the financial circumstances of both parties will be determined, so that the court can make a determination, as its framed issue says, as to what, as Mr. Molnar would say, quantum of modification he is entitled to with regard to his agreed upon and court-ordered obligations to pay what was about $70,000 in support per month and 100% of the add-ons.
Thank you. Thank you both. Myers v. Doherty. Yes, you may proceed.
Good afternoon, Your Honors, and may it please the court. My name is David O'Brien. I'm an attorney at Giskin, Solitaroff, and Anderson, attorneys for the plaintiff appellant, Sergeant Ronald Myers. If someone had read the facts in the complaint and learned that they were true and then concluded that Sergeant Myers was the victim of discrimination and retaliation, would that person be unreasonable as a matter of law?
Counsel, did Sergeant Myers file a federal action?
Yes, he did.
And what happened with that federal action?
The district court applied the pleadings to the
It was
federal law.
dismissed, right?
It was yes.
And why weren't these claims included in that federal action?
Well, the New York City human rights law claim was included in that federal action. As to the New York State human rights law claim, because the human rights law was amended, the state human rights law in 2019, to be liberally construed, the contours of that statute are the same as the city human rights law.
So in the federal action, the claims that constitute the claims here were already a part of that action, correct?
Yes. And the court there only dismissed with prejudice the federal claims and acknowledged that because of the different pleading standards and because of the differences in the substance of the law, his decision, Judge Engelmeyer's decision, did not reach the local law claims.
There was a statute of limitations determination as well, right? The federal court?
There was, as to the federal claims,
Yes.
based on the continuing violations doctrine, which is more plaintiff-friendly in the state.
So could you address the statute of limitations with respect to the city HRL?
Yes. This argument applies with equal force to the state human rights law claims, but under the state human rights and city human rights law, continuing violations doctrine, discrete acts can form part of a continuing violation. That's in contrast to the federal law, as long as they form a pattern.
So do you agree or disagree with the federal court's finding that there was too much of an attenuation between the circumstances prior to 2018, is it? In other words, there was a claim with respect to 2012, 2014, 2017. Those in and of themselves have quite a bit of distance between them. But the federal court said those fall under the statute of limitations. Don't these fall under the statute of limitations here also?
Well, respectfully, Your Honor, while I do disagree with the federal court, with the district court's findings, that was only as to the federal claim, where discrete acts
I
do not
understand
count.
that, discrete acts, but how are these continuing acts when there's so many years between, for example, 2005 and 2018, and you're talking about four occasions that have a spread, one of 7 years, the second one 2 years, the third one to the fourth 3 years?
Yes, this has to do with just how a long career in the NYPD works in reality. After he objected to the racist comments in 2005, the very next day he was transferred away from Inspector Doherty's command.
What year are you speaking of?
2005. And then she only found herself in a position to create a pretext for retaliation when they were both in the counterterrorism unit in 2012.
So in order to show that it's a continuing, that is a continuing pattern, right? What we have here is, we have, as my colleague mentioned, the conduct between, it's 2005 and 2018, right?
That was,
That's what, in the complaint, you talk about incidents which occurred between February 2005 and January 2018. Is that correct?
yes, and beyond that.
And beyond that. So do we have the same actors who are involved in these incidents?
Yes, we did.
And who are the same actors?
Largely Sergeant Doherty and Connery, defendant Connery.
Thank you. You have time on rebuttal.
Good afternoon, Tahira Sadria. Good afternoon, Tahira Sadria, appearing on behalf of the defendants' appellants. As the court mentioned, many of the claims that plaintiff is bringing occurred more than prior to the outside of the applicable statute of limitations, and those actions were disparate actions taking place over with years separating them, and so
But they do seem to involve the one individual. So isn't there some commonality in terms of who that it was she who was involved in all of these incidents in terms of the alleged discrimination?
there is an allegation. The allegation is that Commander Doherty was involved in all of these allegations, but it's not. I think that it's hard to see these as a single action when you're as a single continuing action when you're talking about two instances of disciplines that are different that are taking place, one in 2012 and one in 2017, and two slightly somewhat downgraded evaluations that, but not during the entire period where Commander Doherty is plaintiff's supervising officer or commanding officer.
Counsel, it seems though that every time that this commander encounters the sergeant, that there is discriminatory action or alleged discriminatory action taken. Why can that not be the continuous link here, given the way that the work assignment was set up?
I think that I think that it overstates things to say that every time that there was contact, because you have so there was 2005 where she made the comments in a situation.
What comments did she make?
She made comments. There was about
Ghetto dog?
According to the complaint, racist comments concerning the prevalence of crime in the Black community.
Yes, and those occurred in 14 years prior to.
Well, that was in 2005. So
Yes.
immediately after that, apparently Sergeant Myers is transferred out of that unit, right?
That it is true, that is the allegation. It is true.
And then in 2012, he's transferred to the Counterterrorism Bureau. She's the supervisor there, and apparently during that period of time, she again made statements against him, and then he is transferred out of that unit.
Well, I don't believe that there were any further racially charged statements after he.
Well, the allegation, according to the complaint, is that she imposed unmerited discipline on him.
Right, but that is the allegation, but.
And unfairly downgrading his evaluations.
Yeah, there were two separate instances of discipline that, are 5 years apart, from one in 2012 and one in 2017. There are two allegations of somewhat downgraded evaluations over a 5-year period in which she is his commanding officer.
Well, the allegation as to the discipline is that white officers or white supervisors, white sergeants were not disciplined in as harshly as Sergeant Myers.
Right, but there are no allegations that could make that comparison. There is, while the complaint says that he was disciplined for a schedule change and white officers were not disciplined for schedule changes, there is no allegation into specifically what was this schedule change that was at issue and what kinds of schedule changes white officers were granted. I mean,
What about the allegation about the whites-only bathroom?
the
When
whites,
did that happen?
that's within the statute of limitations. That was happening in 2018. That, I think it's important to recognize that while plaintiff characterizes it as a whites-only bathroom, the actual allegations in the complaint don't make that charge. There's not an allegation that no black supervisors were able to use the bathroom. I mean, I know that the complaint alleges that there was a black
Well, it says,
lieutenant.
even barring Sergeant Myers alone from using a bathroom used by Doherty and other white personnel. So does that not suggest that white officers and Doherty were able to use that bathroom, but he, Sergeant Myers, who was black, was not able to use the bathroom?
It does suggest that, but it doesn't suggest, I mean, again, it's like we know that there was at least one black lieutenant that was in, and it's not clear when it is that lieutenant transferred out. There's no allegation about whether he was able to use it or whether other, I mean, I think that the question is whether or not this was on the basis of race that he was excluded from this bathroom, and the defendant's contention is that there are insufficient specific allegations to give rise to the
So stating from that Myers alone from using, barring Sergeant Myers alone from using a bathroom used by Doherty and other white personnel, that's insufficient?
well, I think there's no allegations in the complaint as to what it was that triggered this. I mean, this is something that is happening some 4 years after
Counsel, are you really answering the question?
I beg your pardon?
Are you really answering the question? The question is whether this is legally sufficient in your mind. The exclusion of an African-American sergeant from a bathroom that white sergeants are allowed to use. Is it sufficient?
Like, does he have to allege an alternative why that happened, other than alleging the facts?
Well, I think he doesn't allege that she's made any kind of comments that raised an inference of discrimination, any kind of racially charged comments, and
Well, the allegation, again, is that it's a continuing pattern, and he does allege that Doherty retaliatory harassment against Myers resumed. So,
I mean, I think that even if one was going to say that this particular action was a discriminatory action and that it was sufficient to raise a discriminatory, I don't think that there is, I mean, if I can just go to the retaliation for a moment, that there is a connection between a 2005 comments and like a response.
Put aside the 2005 comment for a second, okay?
Yep.
Let's talk about 2018.
Yes.
To the extent, as alleged, that there was a whites-only bathroom, and I'm paraphrasing, of course, what is said in the complaint, would that be sufficient to raise a city human rights law question of fact?
If the complaint.
And not being able to use a bathroom is a continuing situation, right? It's not just one time.
If the complaint was sufficiently alleged that there was a whites-only bathroom, then that would be sufficient to raise an issue of fact about, as to the city human rights law. The city's position is that the complaint is not sufficient to raise that claim because the complaint does not specifically allege that only white officers were allowed to use this bathroom, and there isn't an allegation as to, so whether or not there was some other reason why.
But do the facts alleged support the reasonable inference that there was a whites-only bathroom? Not the only inference, but a reasonable inference. Is that one reasonable inference that could be drawn from the facts as alleged?
I think I think that it would be necessary to say that there was no black officers were allowed to use the bathroom in order to raise that inference.
Thank you. So, counsel, addressing that issue, why is that sufficient?
Well, Your Honor, keeping in mind that even if the continuing violation didn't apply, there's background evidence for preceding 2018, and keeping in mind that we not only have a retaliation claim, but a discrimination claim, we have every other sergeant working under Doherty's command is white. She makes keys for them, gives them express permission.
But you don't allege that in the complaint.
Yes, it is alleged in the complaint.
I'm sorry, what paragraph is that? So I will go through the complaint again, but you allege in the complaint that keys were made for the white sergeants and keys were not made for Sergeant Myers?
Yes, and expressed permission to the white sergeants to use the bathroom. And of course, it alleges that she told him that he couldn't use that bathroom.
Is there any allegation that there were any other black sergeants working under that command?
No, Your Honor, he was the only black sergeant, but the complaint does allege that a pattern of pushing out black leadership under her command, that would also include Lieutenant Brooks. And when he accused her of doing so, when he accused her of pushing him out on the basis of race and Lieutenant Brooks on the basis of race, she didn't deny it. And considering—
Well, it says Sergeant Myers spoke with Sergeant Thomas Logan, who told Sergeant Myers that Defendant Doherty gave all the sergeants in the unit, besides Sergeant Myers, all of whom were white, keys to the bathroom and explicit permission to use it. Sergeant Logan then showed Sergeant Myers the key that Sergeant Doherty had given him. Sergeants who received keys and permission included Logan, Rosario, and Guito. Is there anything that states that those individuals named, i.e. Logan, Rosario, and Guito, were not black?
Yes, because it says that all of the sergeants were white, and they were sergeants.
Thank you.
Thank you.
242 10th Investors v. GVC 242 10th Sponsor. Yes, you may proceed.
May it please the court, my name is Daniel Robertson. I represent the plaintiff appellant 242 10th Investors LP here, otherwise known as Investor. By way of very brief background, this case involves a partnership dispute.
Yes, we're well aware.
Great. The court's decision on summary judgment here largely did not reach the merits of the case and erroneously relied on three procedural issues to dismiss the complaint and grant summary judgment in favor of sponsor. Those are timeliness, the notice to cure in the notice of removal at issue, and the release of certain guarantees as a condition precedent. The court's holdings on each of these were incorrect, and I'll go through them one by one to discuss.
Can we deal with the condition precedent first? I know we like to deal with timeliness because that's such a black and white issue most of the time.
Certainly.
Okay.
The trial court erroneously held that the notice of removal sent by investor was not effective because prior to sending the default notice which notified sponsor of that removal, that sponsor had not effectuated the release of sponsor's principals from guarantees related to the partnership property. The LPA does contain a condition precedent. That condition precedent is a condition precedent to the removal of sponsor as general partner. By sending the notice of default and indicating the date of removal, sponsor was not removed as general partner and in fact is still general partner today.
Right.
Therefore, the time for that performance has not arisen. And the LPA expressly contemplates that after the service of the notice of default, that the investor is empowered to speak to the partnership's lenders to negotiate the replacement guarantors that would be necessary to effect that removal, or alternatively, to negotiate indemnification agreements with sponsor. So after service of that default notice, informing sponsor that it would be removed effective February 15th, 2021, the investor repeatedly reached out through counsel requesting to discuss transition issues related to the partnership, the unrebutted
The sponsor cooperate with the investor?
Absolutely not. Absolutely not. They immediately repudiated the notice 7 days after it was received by email on January 20th. And then subsequently, counsel, me personally, reached out to sponsor counsel to attempt to further those discussions and received some very pointed responses that we were not permitted to discuss with any of the partnership's lenders these types of matters, that we should not indicate to any person that sponsor would not be the general partner, and that they would fight this vigorously for years if necessary. And
So
that's
now
where
let's
we
talk
are.
about timeliness.
Timeliness.
So with respect to the email, given the fact that that certified mail delivery was also a component of necessary notice, can we rely on the email?
We certainly can. And that's
The fact that the certified mail came 4 days late,
of course.
what happens there?
90 days from the October 23rd update is January 21st of 2021. On January 20th, investor delivered a copy of that notice by email and also forwarded it by certified mail. That certified mail delivery did arrive after that January 21st date. However, the trial court made a mistake and ignored extensive law in the First Department, including multiple decisions that have been issued in this year. Justice Gonzalez, you were on the panel in the Miracle, New York case, in the AT&T Mobility case. The Maxton Builders Court of Appeals decision applies when a contract requires a written notice, but no written notice of any kind is ever delivered. In a circumstance where a written notice has been delivered, but there is an issue with the form of the notice.
So you're saying that the email constitutes written notice?
The email is a copy of the written letter, and it is indisputably received by sponsor. And there are multiple cases cited in our reply brief where courts have repeatedly held, based upon the Baker case, the reasoning in the Delicari case, the reasoning in the AT&T Mobility case, that delivery by email is effective even if certified mail delivery is required, unless the other side can demonstrate some sort of prejudice that flowed from the precise form of that notice. And there's been no argument to that.
You have time on rebuttal.
Thank you.
Yes.
Good afternoon, and may it please the court. My name is Jonathan Temshin. I'm an attorney with the law firm of Tartar, Krinsky, and Drogan, and we represent the respondents in this. And Your Honor, you went to the heart of one of the main issues, which is the condition precedent that everyone acknowledges exists in Section 4.4 of the LPA. There's no dispute that the appellant failed to comply with it. And we know
What is it? What was a condition precedent to?
To removal. To the removal of sponsor as general partner, they had to do one of two things, either get replacement guarantors or indemnify the guarantors. Those were two things that they had to do before removal.
Does sponsor have an obligation to cooperate with getting the indemnification of the guarantors?
Their cooperation wasn't necessary. There was nothing preventing the limited partner from satisfying the condition precedent. And if you read their papers, they don't actually say what was needed.
Did the sponsor bar the investor from making contact?
No. Section 4.3C of the LPA clearly and unequivocally gives the investor the absolute right to communicate with the lender for the express purpose of replacing the loan guarantors. It says it right in Section 4.3C. They did not need sponsor to do anything. And if you go through the correspondence, you'll see they don't mention anything about this condition precedent. The only evidence in the record where they tried to communicate with the sponsor is this letter where they asked for a discussion about, quote, transition issues.
And just to be clear, the condition precedent is a condition to the actual removal versus a condition to serving a removal notice, right?
Absolutely. And in their removal notice, they set the date of removal, February 15th, 2021. That was the date that they set. That removal notice serves as the basis for their entire case for why they ought to be, or why they satisfied the procedural requirements to remove the sponsor. That letter set the date for which they had to comply with the condition precedent. They set it themselves, and they didn't do a thing. Nothing, zero. They made no effort to contact the bank. They didn't prepare any documents. They could have prepared an indemnification agreement that they signed and transmitted to the sponsor. Here, look, we've satisfied our obligation to. They didn't need sponsor to agree to it. They could have done it. And under the case law, Oppenheimer and MHR, they were required to do it.
Let's go to another area here. Council brings up AT&T Holdings. So,
Yes.
Certainly the email, you received it, what, January 21st?
A few days before the deadline.
So, but it's fair to say that on that date, you were aware of the removal, yes?
We were aware that they had served the removal notice.
Okay, I'm going to go on. You said yes. Now, and then, days later, the certified mailing, and we know what the case law says. So my question is, what prejudice was there? Why isn't AT&T dispositive here?
AT&T relies on Baker. And Baker, and it's a First Department case from 1996, and I asked the court, read Baker. Because in Baker, it talks about this substantial compliance test, and that's where all the case law cites to, the Baker case. But if you look at the Baker case, it says that the defendant waived the strict compliance. It waived it. There was a waiver in Baker that did not happen here. Baker is the only case cited by anybody that tries to resolve the tension that exists between the Court of Appeals decision in Maxton versus the substantial compliance line of cases that my colleague has cited. Maxton Builders is a Court of Appeals case, and the trial court below correctly ruled on it. The line of cases requiring substantial compliance all emanate from Baker, which found that there was a waiver, and there is no waiver here. Now, to answer your question directly about prejudice, there is significant prejudice by this. My client, the sponsor, has fully completed the project, invested all of its time, effort, and resources to develop this, and it's been a complete success. So if they were to forfeit that right, if they were required to forfeit that right, they would lose all of the benefits of their bargain under the deal.
Well, I guess the prejudice question is, what prejudice, if any, was sustained by the late receipt of the notice under the agreement, which was, I guess, what, three to 5 days between, I guess, when you got the email, which facially doesn't comply with the agreement, but then when you get the notice that would have complied but for the day's delay.
So under Maxton, strict compliance is required, and by virtue of their failure to strictly comply with that statute, my client has suffered the prejudice that we've articulated in our papers.
Thank you.
Just briefly in response, there was a question about whether the sponsor had directed or instructed investor not to proceed with attempting to engage the banks with guarantors and indemnity agreements and the like. The email that was sent from sponsor is at our reply brief at page 16, investor has no right to exercise its removal right, and therefore no change of general partner shall occur. Investor and its appraiser and any representatives have no right to speak to any tenants of the property or any lender for the property. Investor should not represent to any person that investor is the general partner or is becoming the general partner. And it states that the GP will vigorously contest all efforts by investor to try to wrongfully seize control, no matter how many years the proceedings may take. Those are the exact words that were received when we attempted to reach out to the sponsor about these issues.
Did that prevent you from reaching out to the guarantors?
Well, in order to line up a guarantor, there's going to need to be a negotiation of a set of agreements in tandem with sponsor and with the bank to accomplish that. And the same is true of indemnity. These are not things that investor can do alone.
So based on that email, it was presumed that you would not be able to engage in that process, right?
It was very clear at that point that the notice itself had been repudiated and there would be no cooperation from sponsor. Yes. So that frustration of the condition precedent itself bars them from relying on that as a basis to avoid removal.
Could you talk about the approval process with respect to the renovation and the costs, the additional costs that were incurred?
Certainly. Are you referring to the negotiation of the original agreement or
I'm talking
the
about the
discussions
the
of
increase, what you define as the sponsor's unilateral expansion of renovations resulting in more than $1 million?
Certainly. Prior to the execution of the LPA, the parties agreed to a $576,870 renovation budget. That was set forth in a model spreadsheet. Excerpt of it is attached to the LPA as Exhibit F. After the property closed, there were changes in the rent law. There was discussions about how the property would be best suited as far as dealing with the new rental restrictions on rent stabilization and the like. Sponsor came to investor in March of 2020 and stated, we've received a $400,000 offer in settlement of another disputed claim. Also, we do believe that we could undertake a substantial rehabilitation of this property. That would be in excess of our original budget. This money could be used for that, without saying how much of that money could be used for that. And in that concluding March 9th, 2020 email, investors' principal stated, assuming the next big topic of conversation will be substantial rehabilitation, please set up a call where you present the budget, the outcome, the projected strategy, and where the building goes from here. That was the last word on that. And there was no further indication that any expansion, much less a doubling of the budget, was going to occur until October 23rd of 2020 when it was revealed for the first time.
Thank you. Justice Higgett, do you have a question?
No, thank you, it was covered.
Thank you. Thank you, Bill. Magdaderi v. Apis Capital. Yes, please proceed.
Good afternoon. May it please the court. My name is Jan Marcus. I'm with the D'Orio Law Group. We represent the appellant. This case involves a operating agreement of a financial services company that the three managing members decided to amend. And the primary reason, though not the only reason, was because the members had provided for a payout for a withdrawn member who withdraws and leaves from the company. The prior formula allowed another member who was not involved in the suit and wasn't around in 2015 to draw payments even though the company was not doing economically well. So that's one thing they wanted to correct. They hired a law firm, and the law firm worked with the company, paid by the company to get it done.
So why was Supreme Court's conclusion that the current operating expenses were intended to be deducted? Why was that not supported by the weight of the credible evidence at trial?
I'm sorry, I didn't hear the last one.
Why was that not supported by the credible evidence at trial? That's the crux of the case, right?
The crux of, right,
So
you're right,
why,
I agree. The crux of the case.
what errors did Supreme Court make?
There are several.
Okay.
This is not the first time this case has been before this court. The court reversed the initial dismissal of the trial court and found that there is an ambiguity between Addendum B, Section 1.09, the components of how the excess net income was to be computed.
Well, this court found that there was a triable issue of fact regarding that ambiguity, right?
Yes.
And so there was a trial.
There was a trial, and I'm going to address now what we think is the error of law. That's the basis of the appeal, that the various aspects of the law were not properly applied by the court. So, for example, when the court writes in its decision after a trial that Schedule E was just merely an add-on, an attachment, and finds that...
Well, it stated that it was supposed to be, I think, that it, not an attachment or add-on, that it was an illustration, I think was what the court stated.
I think the exact words...
And there was
Your Honor,
also testimony...
merely an attachment
Excuse me,
and for
Counsel,
illustrative purpose.
I'm speaking. I'm glad you brought up Schedule E because there was testimony by, the two partners, the drafting attorney, that was really going to be for, illustration purposes, as an example, that it was only the plaintiff who relied on Schedule E, but really the documents themselves, not Schedule E, was really what was controlling here.
That, of course, was the position of the respondents, Your Honor.
So,
the appellant...
and, credibility. I mean, certainly the hearing court found that credible.
So, counsel, I'm
sorry.
I'm looking at Schedule E. I think it's at record 1948. And in the upper left-hand corner, it says Schedule E to Addendum B dash illustration. So if it's an illustration, does that mean that it's binding?
I think it is, Your Honor, because it's often, when you have a contract, whether the illustrations are made in the body of the contract, or it's called a schedule, or a rider, or an attachment.
Schedule is very different from an illustration. We know that.
Especially where you have a provision that calls for the actual calculation of how someone leaves as a partner and how they're compensated, which is Section 109 sub A. Why would E be controlling over that section when E itself is listed as an illustration?
It's an illustration of how that section was supposed to work. And that ambiguity that was created by those two parts of the same contract, nobody caught. And
Who drafted Section E?
Section E was drafted by the appellant,
the
with
plaintiff,
the law firm, Your Honor.
Okay, but by the plaintiff. So any ambiguity was created by the plaintiff, right?
And it's
If in fact it was an ambiguity, but again, given the fact that it was drafted by the plaintiff, don't we construe that against the plaintiff?
Well, in this particular instance, Your Honor,
So why would we not construe it against the plaintiff in this particular instance?
because it's not a situation where the appellant and the remaining partners, the respondents, had differing views or differing goals. He was just tasked, the appellant, with interacting with the law firm. And the evidence was clear that the other remaining partners, the respondents, were asked time and time again to see if everything's okay. Does this mesh with everything that we're supposed to do? And they didn't object. Not only did they object at trial, then they said we didn't pay attention to it because we didn't really think it was important.
You have time on rebuttal.
Thank you, Your Honor.
Yes.
Good afternoon. May it please the court. My name is Deanna Davidian of Arkansas Backen for the respondents. After a 3-day bench trial, the Supreme Court resolved the sole remaining issue among the parties upon finding that they intended to deduct both the customary operating expenses and the income hurdle rate when calculating withdrawal payments. The Supreme Court's finding is amply supported by the credible evidence at trial. As Your Honors,
So, counsel, let's talk about customary operating expenses. The dispute is whether these should apply, right?
correct, whether they should be part of the deduction.
And the appellant is a person who said, I'm withdrawing from the partnership, and customary operating expenses, which are included in 109A, should not be deducted against me. So does that make sense?
Appellant's argument does not make sense, Your Honor. It's contrary to the plain language of the parties' agreement here. And the provision that is directed at calculating withdrawal payments is Section 1.04, which has the defined term excess net income. That's a defined term that's expressly defined in Section 1.09A of Addendum B as current fees less the customary operating expenses minus the income hurdle rate. So it's part of the deduction there. The company's other members, Dan Barker and Eric Alvarez, both testified credibly at trial that customary operating expenses and the income hurdle rate are separate and distinct concepts, and that they intended to deduct both when calculating withdrawal payments.
How do we, if we can, how do we harmonize Section 1.09's definition of excess net income with Schedule E?
They can be harmonized, Your Honor, if net fees are applied to Schedule E. So for example, if, first off, the numbers that are in the schedule are just placeholders. So if you insert net management fees and net incentive fees after deducting customary operating expenses into those rows on Schedule E, so that both customary operating expenses and the income hurdle rate are both deducted, then you can harmonize Section 1.09E with Schedule E. Your Honor, we also had the drafting attorney at Wilson Sonsini testify credibly at trial that Wilson Sonsini drafted Section 1.09A and that it was consistent with the party's intent and that they meant to include the deduction of customary operating expenses as well as the income hurdle rate when calculating withdrawal payments.
Now, counsel, with respect to the customary operating expenses, because you said that there were a number of drafts that were exchanged between the parties, correct?
Yes, Your Honor.
And in fact, appellant reviewed all of the draft and never made any objection regarding the definition.
Correct, Your Honor. We went through the entire drafting history at trial, and in all 12 of the drafts, both customary operating expenses and the income hurdle rate are separate concepts. They are both deducted in all 12 of those drafts. So the entire drafting history supports our interpretation, and the appellant was the one that was primarily liaising with Wilson Sonsini. He reviewed every single one of the drafts. They were all sent to him in red line, showing the changes made to every draft. He then got on the phone with Wilson Sonsini and discussed each one of these drafts. He was the one that admittedly primarily liaised with Wilson Sonsini when drafting the agreement. He was the sole drafter of Schedule E. And I do want to briefly address Schedule E. His entire argument is based on the sample calculation at Schedule E, which again, he alone drafted and asked the attorneys to attach to the back of the agreement. Towards the end of the drafting process, the appellant represented to the other members that he would update Schedule E so that it was consistent with the withdrawal payment provisions in the body of the agreement.
This was the testimony at trial?
It's an email, Your Honor. It's record 1819. It's an email that he sent towards the end of the drafting process to the other members, and he said, we've got some new terms. and I'm going to update the schedule for the new terms. And Mr. Barker, Mr. Alvarez testified credibly at trial that they were focused on the withdrawal payment provisions in the body of the agreement. They thought the schedule, which is just a sample calculation for illustration purposes only, they thought it was subordinate to those provisions and really unnecessary, and that they trusted that the appellant would update the schedule so that it was consistent with the withdrawal payment provisions in the body of the agreement, like he represented to them that he said he would. And the attorney at Wilson Sonsini also testified consistent with that. He testified that his firm drafted the withdrawal payment provisions in the body of the agreement. He understood that appellant was off drafting the schedule that was supposed to be an example of that, and that it was supposed to be consistent with the withdrawal payment provisions in the body of the agreement that his firm was drafting. And he relied on the appellant to ensure that it was consistent, as he said he would. And again, as Your Honor has already pointed out, to the extent that there is an ambiguity, which the Supreme Court found resolved the ambiguity in favor of respondents, but even if there was, it would be construed against the appellant because he was the sole drafter of Schedule E and liaised with Wilson Sonsini to draft the agreement.
Thank you.
Thank you.
Just briefly, I read this court's prior decision sending back the motion to dismiss decision from the trial court to say that there is an ambiguity, and the trial court has to figure out what the intent of the parties was. For the trial court to then go in and say, as a result of what I have found, the appellant had the burden to harmonize everything, and there is no ambiguity, and that's written in the decision. That really poisons the entire decision as far as the appellant is concerned. Of course there was an ambiguity. That's the whole point. So the reasons set forth in the brief dealing with the trial courts one after another, saying that there was the appellant was the drafter, as we've gone over, and there was no meeting of the minds, and Section 1.09 is clear. It's not the way you resolve an ambiguity by saying one section is clear and one section is a little more complex. That's
Sir,
not right.
at one
That's not
point
right under
in
the
her
law.
post-trial decision, the trial judge observed that the definition of excess net income had never changed from draft to draft. I think Judge Kennedy asked your friend a question along those lines. Isn't that fact entitled to significant weight in resolving the ambiguity, that critical definition never other things did change that are germane to this appeal, but that definition remained static?
I think you have to, Your Honor, to address that, you really have to put that in context. And if the appellant was tasked with interfacing with the lawyers, and it was felt necessary to draft something like Schedule E to give examples of how things work, the specifics usually trump the general language of a contract. If there are examples given, they're given for a reason. They're going to say, this is how it's supposed to work. And when the appellant goes back to his partners and say, look at this, make sure you're okay with it, is the math right, is everything okay? And it's not that they yesed him to death, they said, yes, I reviewed it, the math looks right, that's in the record. He's thinking, and rightly so, that this is the way it's going to work, this is the way it should work. The fact that nobody caught that ambiguity and dealt with it at the time should not be shouldered all by the appellant. It's the respondent's responsibility, and quite frankly, it was the law firm's responsibility, but that's not involved in this appeal.
Thank you. Thank you both. People v. Isaiah Felix.
Good afternoon.
Good afternoon.
Hannah Wallace for Appellant Isaiah Felix. In directing the prosecutor to send the grand jury minutes, the court even
So the first issue is, the threshold issue is the waiver of the right to appeal. Why is that not a valid waiver and therefore forecloses further discussion?
Yes, Your Honor. The court, in its oral colloquy, did not tell Mr. Felix that he would normally retain the right to appeal even after pleading guilty. And that's the critical language that the court omitted.
So the waiver of the right to appeal tracks the model colloquy, which the Court of Appeals has upheld in People v. Thomas. The court separated the right to appeal from trial rights, and not only that, we also had a written waiver of the right to appeal, which would cure any issues, if there were any issues, with the oral right to appeal, a waiver of the right to appeal.
So the oral colloquy does not exactly match the model colloquy, and although it doesn't need to, in this case, it leaves out critical language that does not make clear that Mr. Felix had
So what critical language does it leave out?
even after pleading guilty. So would normally still have the right to appeal even after pleading guilty. And in omitting that, the court failed to make clear the way that trial rights and the right to appeal are categorically different, in that Mr. Felix had the choice to waive his right to appeal, whereas trial rights are automatically forfeited upon his pleading guilty.
Ordinarily, you could appeal a case, and by giving up your right to appeal, that is a separate right from giving up your right to a trial. In this case, you were asked as a condition of your plea, since you are receiving a benefit from this plea, that you should give up your right to appeal. So what is an appeal? And the court goes on. This is not sufficient to inform the defendant as to what his rights are, and the fact that he is giving up the right to a trial and giving up the right to appeal?
It's not, Your Honor. Even though
I'm not understand. I just read it. I don't understand why that it would not be clear to a defendant that he has a right to proceed to trial.
So even though the court said that the right to appeal was separate from trial rights, it didn't say how they were separate. And without that clarification, the colloquy implied that the appeal waiver was just another automatic consequence of his pleading guilty, which it was not. And the written waiver also left out that critical language.
Counsel, you talked about the fact that the court didn't advise your client of his right to a lawyer, but it says right here, if you cannot afford a lawyer, the cost of the lawyer, the state would bear those costs. So how did it not advise the defendant that he would still be entitled to a lawyer on appeal?
We're not making that allegation.
Oh, I thought you said that earlier.
Just want to direct us back to the 3030 issue. The court specifically asked the prosecutor whether he had the correct court attorney's email address, and the prosecutor responded that he did, and then he sent them to the wrong person anyway.
Wasn't the email address supplied by the court?
So, no. The record
It was in the chat. I thought it was in the chat. It was in the virtual chat box, right?
So
that was the email that was in the chat. That was the email that the prosecutor, when responding to the court's question as to whether or not he or she had the correct email. That's what the prosecutor was referring to.
Right, so the record has no mention of what was actually in the chat. What happened on November 9th
But
was...
it mentions who, right? It mentions the name of the court attorney.
Not on November 9th. The judge says, do you have my court attorney's correct email? I believe it's in the chat from earlier today. And then
That's what the court stated.
Yes.
The court stated, I believe it's in the chat from today. So the
Yes.
court is directing the prosecutor to the email in the chat for that day, and directing the prosecutor to send the materials to that individual at that email.
Yes, and then the
And
prosecutor...
it turned out that that was the incorrect email.
So the prosecutor makes no reference to checking the chat. It just says, I have it, and then that's it.
I'm not understanding. The court directed the prosecutor to send the grand jury minutes to the individual at the email listed in the chat. And that's what the prosecutor did?
It is our position that that person, there's no logical inference that would suggest that that person was in the chat. The trial court below found...
And that's based on what?
The trial court below, in its 3030 decision, found that the prosecutor had sent the grand jury minutes to the wrong court attorney.
Okay, but even assuming, yes, and that did occur, does there not have to be some type of showing or determination that this was more than an inadvertent error on the part of the prosecutor?
So because this was not a reasonable error, That is why that this
Why, so that's my point. Why would that not, why would that be unreasonable? If in fact the Assistant District Attorney relied upon the information in the chat supplied by the judge?
So it would make no logical sense for Judge Mitchell to have directed the prosecutor to send them to the wrong person.
I'm sorry,
So
what did you say?
it would make no logical sense for the judge to direct the attorney.
What the judge did was direct the prosecutor to the name in the chat. And you probably are not aware of this, but forget it.
Thank you.
Thank you.
Good afternoon, Your Honors. Andrew Loizides, appearing for the people, and may it please the court. To begin, Your Honors, the defendant validly waived his right to appeal. The waiver was knowingly.
Well, what about your friend's argument that the defendant was not made aware of the fact, I guess, that he could proceed to trial and that he was waiving certain rights regarding that?
Well, as we mentioned before, the court followed the model colloquy that was approved by the Court of Appeals. The defendant was represented by competent counsel that confirmed, and he confirmed on the record that any questions that he had, he went over with his attorney, and he was satisfied by his attorney's representation, and that he also reviewed the written waiver of the right to appeal that clarified any deficiencies that were within the oral colloquy. So it stands to reason that if the defendant had any issues not understanding something, that he had counsel there to advise him and to answer any questions he had. There's nothing here to suggest that he didn't understand, that he didn't have. That he wasn't aware that he wasn't going to have attorney representation for appeals.
And in fact, the court also advised a defendant of the claims that would survive
Correct.
the waiver.
Correct, Your Honors. Yes.
I'm going to go to another area. I'm going to go to the 3030.
Yes.
Because obviously it was an inadvertent error. And it wasn't until the date of the decision, I believe it was February 1st.
Yes, Your
The
Honor.
people learned about this error.
Correct, Your Honor. And if I may, immediately the moment that the people discovered that we mistakenly sent this to the wrong email address, the people immediately sent it to the email address provided by the court at the February hearing. If this was a mistake, it was a reasonable mistake, not a moment of prosecutorial inaction. This was a reasonable delay, and therefore it shows
Is there
that.
any information in the record as to how the prosecutor ended up with the wrong email address?
As alluded.
Anything confirmed outside of the judge stating to look in the chat and take the email from the chat?
Based on the record, that is what it was established, that at the hearing that the judge said, you have my court attorney's email address from the chat, and and our side said, yes, we do have that, Your Honor.
But, I mean, the record does show that there's no relationship between the individual's name and email that was in the chat to the judge's actual court attorney. And that individual whose name and email was in the chat had no relationship either to the judge or to the part.
I suppose if that were the case, then again, it was a reasonable mistake that was made, but we did send it to that email address in good faith, believing that was the correct email address that we.
Any responsibility or burden on the assistant to ensure that he or she was sending it to the correct court attorney?
Based on what the 3030 is, just to show that as long as we acted reasonably, which we did in the circumstances here, then we did precisely what we were supposed to do in following the instructions. And
Counsel, would it be fair to say that it was the court that made the mistake in giving the wrong email address?
I would say that there may have been a miscommunication, I think is fair to say.
So nice of you to say.
Well, I mean, we don't know whether the prosecutor assumed the name of that court attorney.
No, there's nothing on the record to assume that, Your Honor. That's speculation at best. But so, again, if there was a mistake made, it was a reasonable error and one that was corrected immediately once it was brought to our side's attention. And, Your Honors, just to briefly mention, too, the sentence that defendant received is not excessive given the crime. And unless Your Honors have any further questions, the people respectfully submit the rest of the argument on the brief.
Thank you.
Thank you.
Thank you. I know there's some confusion about what or was not in the chat. It is our position that the incorrect court attorney was not in the chat, and there's no record support to indicate that he was.
How do we know that? What information do we have
So,
to establish that on this record?
so there's no indication that, well, we know that the trial court below decided that it was the wrong person, and the logical inference is that the judge would not have directed the prosecutor to send them to the wrong person.
So we're assuming that it was that the right person was in a chat, but the prosecutor emailed the wrong person?
So I think it's very important that live on the record, the prosecutor that makes no reference of I'm checking the chat, doesn't clarify orally, is it this correct person? And this comes at the heels of already being told that he made a mistake the week earlier when he failed to attach the minutes initially to his motion on November 5th. So we have an attorney being told, you already made a mistake, and any reasonable attorney would do their due diligence to make sure that they have the right person.
So wait a minute, you're saying if you get an email address from a judge or from the court in a chat, you would disregard it?
The record is
and
silent.
double check to see if the judge gave you the right email address?
The record is silent as to whether this person's email was in the chat.
So you're saying that that somehow there's an assumption that the prosecutor looked in the chat for the email or did not look in the chat for the email?
I think that when the judge says, I believe it's in the chat from earlier today, the prosecutor only responds, yes, I have it, and doesn't say anything about checking the chat. It would suggest that he just thought he had the right person and then sent it to the wrong person, and we know that that is not reasonable under the circumstances. The court did more than enough to supply the information to the prosecutor.
Thank you. Thank you, Belle.
Thank you.
Ari Realty v. 18 East 69 Street Tenants.
Good afternoon, Your Honors. James Schwartz from Cucker Marino for petitioner appellant Aria Realty. Article 45 of the party's lease says that the tenant has a $225,000 rent concession. It goes on to say, for the first 3 months of the lease, it goes on to say that if the tenant defaults at any time during the 3 years that the lease was to run, the concession would be recoupable by the landlord.
Now, respondent says that you didn't raise that argument before the trial court.
It absolutely was raised. It's in the trial transcript. It's in the trial transcript, closing argument. Counsel says that it is trial counsel said that it was forfeited, that Article 45 controlled. Counsel says that basically every argument that we make was not made below, and that's, quite frankly, nonsense. We argued below that the lease controlled, every provision of the lease controlled over the so-called oral arrangements that changed it. The issue is that the tenant admittedly defaulted. If you look at the tenant's own ledger at record page 298, and if you look at the judge's own finding, the judge's own finding was that the tenant defaulted at various points.
Even on the allegation of a reduced rent?
That's correct, Your Honor. Even on the allegation of a reduced rent, they weren't. The tenant said it was supposed orally. The oral arrangement was that they were supposed to pay $60,000 a month. The lease says $75,000 a month. But, Your Honor, the tenant's own ledger at 298 of the record shows, for example, August 2020, $60,000 rent not paid. September 2020, $60,000 rent not paid.
Well, plainly there was a default, and the judge acknowledged that. But 45 seems to be a little nuanced in that it talks about the rent credit shall be recaptured in the event during the term of this lease through and including February 28, 2023. The tenant shall default beyond any applicable notice and cure period. So we need to know not only that whether there was a default, and I think we know that here plainly, but then was there a default beyond a cure period?
Well, several issues on that. There are in the first of all, this was a non-payment proceeding, so that there were in the record there are 5-day notices and 14-day notices of non-payment, and ultimately, the trial judge found that there was $161,506 in rent that was due, other than the concession, and so that in and of itself goes to cure and notice and cure, Your Honor.
So did you challenge the $15,000 concession below? Are we agreed that the rent is $60,000?
Absolutely not.
I'm sorry, absolutely not what?
Absolutely not $60,000.
And you did challenge.
Of course we challenged it. That was the whole point. We said the lease controlled. In order for that $60,000 to control, you have to have either part performance or equitable estoppel. For part performance and equitable estoppel, under the
So how is part performance not shown by the ledger? We have the ledger that's produced by the son on the day of trial, and we have the ledger that's produced by the tenant, plus checks, plus an email from Benjamin, the father. How is there an issue of fact, and how is there not performance?
Two points on that, Your Honor. For part performance, you also need consideration. That's black letter law. You need consideration, and there is none here, because even if it's all true.
Did the father testify at any point that there was no consideration?
Well, the consideration.
The father was Benjamin.
Right.
He was not incapacitated to the knowledge of the court in any way.
The consideration that the landlord received was just a lessened rent, and that under the case law is not consideration. It also has to be that.
As you, but did Benjamin the father say that?
He did not testify, but the tenant herself testified, and it's in my briefs, that there was no consideration for the for the oral arrangement. May I
Yes, you have time on rebuttal.
Thank you.
May it please the court, I'm Ned Basson from Denton's U.S.
So was Article 45, was that addressed before the Supreme Court, before the lower court?
Yes, I would like to clear up.
Because I didn't see any mention of it in the, any specific reference to it in the court's order.
Okay.
Nor by the appellate term.
But I think I can clear this up. There were two separate proceedings. One was a bench trial, and then there was a decision. The decision said that there was a $15,000 a month rent credit. After that, there was a separate proceeding before the same trial judge on the calculation of the monies owed.
So the $15,000, that was, according to the court and according to the appellate term, that was based upon an oral modification.
Correct.
As well as part performance.
Both.
Right.
Both.
Yes, both.
And as Your Honor mentioned, there were several written documents substantiating that.
So how did Article 45 play into that?
Okay. Because it was not raised. When I say why wasn't it raised, there were two separate proceedings. In the first proceeding, it was raised, and the trial court said no. It's not equitable. In the second proceeding,
The trial court said that it wasn't equitable?
she said all the other monies claimed would not be equitable if it were ruled that they were owed. That's what she said. But in the second proceeding, where the judge calculated the amounts owed, and by the way, there was no dispute that the tenant was going to pay whatever needed to be paid. In the second proceeding, the judge went line by line and calculated. And here's what the judge wrote on page 2 of her November 6, 2023 decision. Quote, all parties agreed that based on the court's determination of the rental amount Respondent's balance owed is $161,500. All parties agreed.
Well, that's because they have to take the September 20th order as they find it. And in the September 20th order, the judge addresses specifically the rent concession. It does it concisely, but says petitioners equitably is stopped from seeking the full rent under the lease or recoupment of the 3-month rent concession.
That's right, Your Honor. However, when the judge said this, and I was there, so I know what happened. He was not. The landlord could have said, no, we do not agree that it's $161,500 owed because of Article 45, because of this, because of that, because of
They
whatever.
were already stopped from doing that based on the previous order.
No, why were they stopped?
They have to object a second time on the same point?
No,
Because you stated that on the first order, during the first proceeding, the judge stated that that was not to be considered.
okay, but then the judge is going through, and then a second time around, she said, do all parties agree that this is the amount owed? Why couldn't the landlord just said, no, we don't agree that that is the amount
So are you
owed?
construing that as waiver?
Yes, it's a waiver. It's a complete
Because they did not
waiver.
raise it on the second time.
Exactly. They could have said, no, we do not agree that is the amount because
Okay,
they also...
the orders are going to be in the record, so that's fine. I mean, you can use your time however you'd like. I just, for my part, I'd like to hear maybe a substantive rejoinder to the Article 45 point.
Well,
Not wait, well, you've made the waiver point, but now with respect to the judge's findings in the September 20th order.
Why would that be correct?
I'm sorry.
Why would the judge's order or findings be correct as to Article 45?
Because the judge was determining, first of all, there was no admissible evidence whatsoever.
We have the lease that
Yeah.
contains the
Okay, we
provision.
have the lease. Do we have admissible evidence as to what happened under the lease?
Well, we have the ledgers where it's indicated that there was defaults.
We had two ledgers, the correct landlord ledger and the phony register they made day of trial, and the trial judge makes note of that.
Well, regardless of phony, correct, in either ledger, there were defaults wherein whether the rent was $60,000 or $75,000, neither was paid.
No, she did. There were only certain periods of time when she didn't pay the $60,000.
Right, so there was a default.
So you have the lease, which contains the article, obviously. You have the ledgers. Why is that not admissible evidence?
There was no admissible testimony, and the landlord looked to introduce a phony the first ledger had all the credits in the ledger by the landlord. The phony ledger removed all the credits.
Are you now arguing that there was no default?
Yes, I'm arguing there was no equitable default.
Thank you.
Wow, just wow. At page 158 of the record, I will read to you from the transcript of the trial counsel's closing statement regarding Article 45.
I'm sorry, sir, are you reading for something that preceded the judge's September 20th order or something that preceded the judge's November?
Preceded the September 20th
Okay.
order. In addition, the lease specifically provides for a rent concession in paragraph 45 thereof, but specifically states that if the tenant is in default of the lease beyond any applicable cure period, the rent concession of $225,000 may be recaptured and specifically may be sued for in a summary non-payment proceeding, which is exactly what happened. It was argued below. Now, we heard all about this, this accounting. That was a methodological, not even a hearing. There's no transcript of it in the record. There was no transcript made of that. So
Counsel, do we have enough facts in the record to make a determination about the clawing back the rent concessions?
Yes, there are, because the tenant's own ledger at 298 of the record effectively admits, the tenant's ledger admits that there were defaults, and quite frankly, defaults galore.
And how does that play into the notice, beyond the notice to cure period?
Well,
do we have enough information to make that determination from the record?
The answer again, Your Honor, is yes, you do, because we have, first of all, I don't believe the lease has any provision in it. I looked at it last night. I don't believe it has any provision in it that says the rent is not due until we give you, for purposes of a conditional limitation, till we give you a notice to cure.
Not for a conditional limitation, but
Right.
for the applicability of 45.
Yes, for 45, for a non-payment proceeding, and we did that. There are predicate notices in the record, and then the proceeding went forward, and it was based on those notices, Your Honor.
Thank you, Bill.
Very welcome.
United Legwear v. All in the Cards.
May it please the court, Daniel Horner for the appellant, United Legwear Company. First, I'd like to emphasize that the facts presented by the appellant are undisputed. The respondent failed to support her own motion to dismiss.
So we have a general release which appears to release everyone. Is that correct, or does it not?
If it became effective, yes, it would have released everyone. It's appellant's position that that general release never became effective.
Interesting argument. You're arguing that it did not become effective because it was being held in escrow, and somehow that the escrow meant that it would not become effective, or would not become effective unless all the conditions were met?
Certainly, yes. That's exactly the argument, because the condition to the effectiveness is the payment upon which the release was premised. If the payment never occurred, then the release would have never taken effect. I don't know that you have to resolve the question of whether or not the release was actually in escrow or not. If it was in escrow, then certainly it never became effective until the payment was made. However, before that payment was made, the general release was superseded by the limited release, which specifically preserved the appellant's claims against the respondent. Now, take the other side of the coin that it was never escrowed. The general release was still conditioned on the receipt of consideration, which was not paid until November 18th, 2023. On November 14th of that year, the general release was replaced with the same limited release. So either way you look at it, the general release never became effective, and the appellant's claims against the respondent were preserved.
The general release says all releasees, past and present officers, directors, shareholders, and members, managers from all actions, causes of action, suits, and demands whatsoever arising out of the note and Ms. Ree's personal guarantee. How does that not release everyone?
So it's not a question of whether or not the general release would have released everyone. It's a question of whether the general release ever became effective.
Was it signed?
It was signed, yes.
Was it dated?
It was dated.
Was it a complete legal document then?
It's a contract, essentially. It's still premised on
Right,
consideration,
but did it have-
future consideration, which had not yet occurred. Without receipt of that payment, the general release does not still...
Was there language that said the release is conditioned upon?
Yes, the general release itself says that it's in consideration of the receipt of
It says
payment.
in exchange for a payment of.
Correct. And that payment
But
did
in
not occur.
exchange for payment of doesn't say future payment of, right?
Well, there's no dispute of fact in the record as to when the payment
I'm
was
talking
made.
about the language.
It says it says general release date, it's September 21, 2022. The parties agreed that in exchange for a payment of, which would seem to suggest that the release was being given because there had in fact been an exchange, a payment of $1.1 million.
Yes,
It does
but
not say that
that's not
upon,
correct.
it does not say that upon receipt of,
It
the
says
parties
in-
will be released. It
in
says
consideration of the sum of 1 million plus
in exchange
receipt
for
whereof is
payment.
here acknowledged.
Right.
However,
Wait, in consideration for, go ahead.
so
No. Didn't you say receipt?
yes,
You
receipt
did say
whereof
receipt.
is hereby acknowledged.
So receipt
However,
means
that's
got it.
because
No,
this
no,
document-
Counsel, you have to wait for my colleague
I
to complete
apologize.
the
Yes.
question.
In consideration for receipt of means I got the money, right?
But they didn't get the money.
But-
There's
Right,
no
but you didn't
receipt
write
of
that. That's not what, that's not the language that's written in the release.
What this document means and the intent of the parties was that this is being placed in escrow with a depository.
That's not what it says.
No, because this is pursuant to a settlement agreement where that was contemplated. It was the party's intent. That was the contemplated
Where does it
intent of
say
the
that in
parties.
here?
It's not going to say that in there. Basically, the escrow agent is holding the
So
document.
how is anybody supposed to figure
Please,
that out?
Because the parties to the transaction understand that. When the payment is made, the escrow agent gives this document to the payee, and at that point in time, receipt of the payment is being acknowledged.
Did the September 19th settlement agreement prescribe the form that the releases were to take?
Yes.
And did the form of the September 21st releases conform with the form specified by the settlement agreement?
Yes. And then after, pursuant to the settlement agreement, specifically paragraph 15, which permitted the parties to revise and execute such further documents as which were required to further their intent, the parties substituted this general release for the amended limited release, which squared with their intent. The respondent was never meant to be a beneficiary of this transaction.
So I'm looking at record page 99, which is the settlement agreement, right?
Yes.
And in paragraph 3, it says, in full consideration for this agreement, Ms. Ree promises to pay the full amount of the indebtedness at the closing. And then that is followed by the general release, which says, here, this is in receipt of. So don't those two go together? I promised to pay and I received it.
These are all part and parcel of a transaction that's occurring in a future date. So this general release was supposed to be placed in escrow to be delivered upon the condition occurring for the delivery from escrow. Because that condition had not occurred at the time the general release was
So if I buy, I don't know, a car from you, and I haven't paid it, and you give me a receipt saying it's paid, that's how it works? That's how consumer transactions work or commercial transactions work? You keep the receipt, you give me the receipt, and or someone keeps the receipt in a drawer until I've actually paid? That is the strangest.
I mean,
that is so strange.
So you're suggesting that you would never pay for the car, but I gave you a
No.
I'm suggesting you have time on rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Daniel Shimko for the respondent, Allison Udid Misri. I submit that there are three main points here. The first is that the September 21st, 2022, the September 21st, 2022 general release unambiguously discharges the primary principal debtor all in the cards. So does the second release, the one on November 14th. So
Did either the original release, the September 21st release, or the settlement agreement contain any conditional language about the effectiveness of that release?
not that I'm aware of, Your Honor. Not that I'm aware of. It was conditioned on the payment of money, but the documents themselves say that that condition was met.
Was there anything that stated that the escrow was required and that the monies had to be paid?
There wasn't anything that said that it was required. There was contemplation of escrow, but there was never any prescription of how the escrow would be done. There wasn't any escrow agreement. There wasn't any escrowee named or anyone who acknowledged that they would be the escrow agent. And the fact that we have the releases suggests that there wasn't an escrow. We can kind of backpedal and see what happened here. The appellants filed this action on July 21 of 2022. Respondents filed an action with a motion in lieu of a complaint on behalf for the debt. On November 4th, my clients filed their opposition with attaching the September 21st release. 10 days later, they execute the amended releases and then submit those to the court to say that this was.
Well, their argument is that they executed those releases at that time because that's when they received the actual consideration, not that they executed in order to kind of thwart this action.
No, they admit that they changed these releases because it was a mistake. It
was a mistake, and it was before that they received the consideration. So according to their argument, the consideration was the condition upon which the release was premised on.
That's their argument, Your Honor, but we submit that the consideration is both the promise to pay and the depositing of the release into the escrow. It's our position that the whole purpose of an escrow is that once the property is in there, the escrow isn't going to allow it to be changed before the actual occurring event occurs.
And it becomes irrevocable. Then it becomes irrevocable.
It becomes irrevocable, and because certainly here, it's not a mistake that just these three people can fix, because now we've got a document with all in the cards with my client as a member of a defined class who has rights under this contract. So for them,
Well, but also your client's the one who didn't pay their portion of the debt.
That's neither here nor there, Your Honor. Respectfully, in front of this court, the acknowledgments are that the debt is discharged. I mean, would Your Honor like me to go outside the record? Or?
No.
Okay.
Is there a triable issue of fact as to which of the two releases is the operative document?
Again, I don't think it matters because they both release the primary debtor, and when you release the primary debtor, you're now it's not. The courts have recognized that you can't release the one who's principally responsible and then go after the person who is secondary responsible without proper notice and without there being actual consent to such a change or modification to the underlying debt, and that has not happened here.
Thank you.
Thank you, Your Honors.
So one thing I'd like to clarify there is that the limited release did specifically reserve the appellant's claims against the debtor to the extent of the amount that remained owed by the respondent. So it is actually very important as to whether the general release or the limited release took effect.
So the debtor was not entirely discharged under release number 2.
Correct.
And speaking of release number 2, there was nothing in release number 2 that indicated that release number 1 was revoked.
No, so that was, a lot of this took place as part of an oral transaction between the appellant and Alex Misery on behalf of all in the cards. But that's all part of the factual record here, which is undisputed. You have no alternative version of the facts that's been presented by the respondent. So the court really is constrained to accept the appellant's versions of the fact. Again, the general release did not become effective because payment was not made. And payment might have never been made had the closing on Alex Misery's property and the proceeds of the sale of that property gone towards payment.
Was there any provision that said it's not going to be effective until payment is made? Was there any such provision?
So that provision is in the settlement agreement. You have to read the documents together. The settlement agreement provides that the payment's going to be made in the future.
But it's not in the release. It's not in the release.
No, because the release is supposed to be delivered at the closing of that transaction. And in that context, it makes sense for the release to reference present time. But until then, it's being held by the escrow agent. It's not effective and doesn't become effective until that closing occurred. And because the closing had not occurred, the parties were within their contractual right and the language of the settlement agreement to amend the general release and replace it with the limited release, which specifically reserved the claims against the debtors and respondent to the extent of the amount that she owes.
Thank you. Explain v. New Gold Equities. Yes, you may proceed.
Good afternoon, and may it please the court. My name is Marissa Mbola with the law firm of Sokoloff Stern LLP on behalf of the appellant New Gold Equities Corp. From our perspective, there's really two key issues on this appeal. They have to do with whether the New York City Administrative Code, Section 16-123A, creates a 4-hour grace period for property owners to remove snow and ice, and whether that grace period begins to run when the snow ceases to fall, as is a direct quote from the statute, or at some earlier time.
Isn't that a question? Is the record clear as to whether there was still a storm in progress or not? Meaning, had the storm ceased 4 hours before or after 4 hours?
Your Honor, our position is that the record is clear that there was a storm in progress all the way up until 3:30 p.m.
So your experts opined that the snowstorm ended less than 4 hours before plaintiff's accident.
Correct.
Plaintiff's expert opined that the snow, in fact, ended more than 4 hours before the accident, and there's only a trace precipitation of snow after that. So now, are there not, by that alone, issues of fact?
No, Your Honor. Here we think that is really a construction of 16-123A, which says that every owner shall, within 4 hours after the snow ceases to fall, remove the snow or ice. We have both experts agreeing that the snow continued to fall until 3:30, and plaintiff's own expert in his analysis suggested that even in the period of time that may be under dispute, that up to half an inch of snow had accumulated. We think that makes this very different from the other trace precipitation cases where a much larger period of time elapsed and where the precipitation that was in dispute was significantly lower. At this point,
You're taking the language trace amounts of precipitation at 2, 3, and 4 p.m., which was testified to or affirmed by meteorologist Wright as meaning that it was snowing?
No, Your Honor. Let me
That's the plaintiff's expert meteorologist. And I don't see anything that says it was snowing.
No, we don't have anything that says it was snowing. Or excuse me, do you mean at the time of the accident or at 3:30?
At 3:30.
A plaintiff's expert does testify that it was snowing at 3:30, and that small
Trace
flurries.
amounts, that's my question. Trace amounts of precipitation. You assume that language to mean it was snowing? Trace amounts?
Well, Your Honor, the expert said that there were small flurries, and then he also said later, and this is a quote, the NWS reported 9.4 inches of snowfall at Central Park and 10 inches at LaGuardia, but he also—
That's accumulation, right?
Accumulation.
Okay,
Said that the accumulation through 1 p.m., which is the time that they're saying only trace precipitation considered.
And moving along, do we also have an issue as to the manner in which the snow was removed?
Well, before we get there, we also have the testimony from the plaintiff as well as from the police officer
Right.
that it was not snowing and that there was no precipitation whatsoever.
Yes,
So
Your
again, does that not create issues of fact as to whether or not there was a storm in progress or not?
No, Your Honor. As our argument is not that there was a storm in progress at the time of the accident. Our argument is that a storm was in progress until 3:30, and under 16-123A, we have 4 hours after 3:30 to remove snow, and that the plaintiff's accident occurred within that 4-hour window.
And so the other issue is in terms of the lessee of the property was a sandwich shop?
Yes, Your Honor.
And so under your lease agreement with that, was it Carve Out or Crave?
Carved Deli.
Carved In, Crave, that under the lease, they were responsible for snow removal?
Yes, our argument is that under the lease, they're responsible for snow removal, and at the very least, based on the evidence in the record, the court can search the record to see that New Gold's, the appellant, had conducted no type of snow removal, did not have any employees involved in the snow removal, and that it should be, its cross-claim for indemnification against Carve should be granted at the very least.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Robert O'Hare from O'Hare Parnegian, and I represent the respondent in this action. I think the bench has already hit on what the main issue is in the case, and that is whether there's a question of fact regarding the finding by Judge Hagler that there was no defense of a storm in progress. And the judge found that by looking through the record, and particularly with respect to the expert report by Mr. Wright. Mr. Wright actually set forth what the trace amounts of snow were, and they actually started a little before 1 o'clock. If you look at the record at 587, where it shows the climatological record of.
That was your expert, right?
That's right, Your Honor.
So your expert stated that the snowstorm had ended more than 4 hours before the accident.
That's right, Your Honor. If you look at the measurements or the precipitation that was set forth in that chart that I referred to, from 12 until 1 o'clock, there's 0.03 inches of precipitation. From 1 to 2, 2 to 3, 3 to 4, there's 0 recordable precipitation. And even the expert, the defense expert, had said that anything below 0.05 inches of precipitation is essentially immeasurable. And so in this case, our expert opined that at a minimum from 1 until almost 7 o'clock when the plaintiff fell, there was no measurable amounts of snow. And in fact, the snow, and I think everyone agrees to this, any kind of snow, flurries, a dusting, there's no dispute that stopped at 3:30 at a minimum.
And so she testified that she fell between, I think, 6:45 and 7, right?
Yes, Your Honor.
Yeah, and I'm looking at the photographs, record 883 and record 888. Is there an issue with respect to the manner in which snow removal was effectuated, or do we not concern ourselves with that?
Well, that could be an alternative basis for affirming Judge Hagler's decision. As the judge found, there was a question as to whether the defendants caused or created or exacerbated the dangerous condition. And there was evidence that although the snow was shoveled, and I don't think that anyone disputes that, in fact, that was admitted in oral argument, although the snow was shoveled, when the snow was removed, the testimony is that it left bare chunks of ice, patches of ice, and that the proper course would have been at that point, because that would have been dangerous, to salt or sand it. And the
I think
testimony.
there was testimony that they never really instructed the workers exactly how to remove the snow.
That is true, Your Honor. There was no instruction whatsoever.
Is there a schedule?
No schedule. There's no schedule, there was no log, and there's no evidence that the owner of the property, in this case the appellant, sent anyone there to even inspect the property. And the testimony in the record is the owner's representative who testified, Mr. Mineta, who was the property manager for all properties that the appellant owned, and also the president of the corporation that owned the Carved Deli at the location. When they were shown the pictures of the condition on which the plaintiff testified she fell, they both admitted that had they seen something like that, they would have directed their employees to go back out there and correct and make safe the dangerous condition. So as Judge Hagler said, the plaintiff, the defendant in this case, the appellant, doesn't get the advantage or any defense of a storm in progress.
Thank you.
Thank you, Your Honor.
Counsel, just to follow up with the questions that were posed to your friend here, to the extent that you say that it continued to snow, do we have a record or any evidence as to when the sidewalk was last cleaned?
Not that I know of, Your Honor. I know that the appellant, a party for the appellant testified that they would normally wait to be told if there was some issue because they manage so many different properties, and that they didn't hear anything from Carve, the tenant, about any particular issue. But I don't know offhand if there's anything in the record that specifies when exactly it was last inspected. If you have no other questions, I just wanted to briefly, actually, I think we just raised it, so that was my last point. Thank you, Your Honors, unless you have any other questions.
Thank you both. Thank you. Alvarez v. 471 West 144. Yes.
Good afternoon, Your Honors, and may it please the Court. Adam Grogan on behalf of Defendant Appellant. Your Honors, there are two circumstances under which post-note of issue discovery is permissible, neither of which are applicable here. Under 22 NYC RR 202.21, under subsection D, requires unusual and anticipated circumstances that develop subsequent to the filing of the note of issue, and the certificate of readiness, which requires additional pretrial proceedings to
You don't
prevent.
think that unusual circumstances were presented here?
No, Your Honor, respectfully, I do not, because all of the issues that my friend points to in order to justify post-note of issue discovery were plaintiff was fully aware of before the filing of the note of issue. The sale of the property was public knowledge on ACRIS as early as 2017, and the sale of the property was disclosed prior to the filing of the note of issue in June of 2019.
With regard to the interrogatories that were served, were they responded to appropriately?
Yes, Your Honor, they were. The court below based its granting of a post-note of issue deposition of a non-party defendant on their allegation that the interrogatories were not properly responded to. However, that is not accurate. The trial court stated that the interrogatory requests, such as ascertaining the party to whom 471 West 144th Street was said or was sold to and when, incited to the response to interrogatory 9. But if we look at interrogatory 9 on page 90 of the record, it plainly identifies that the property was sold on September 8th, 2017 to Martha Schwartz.
I'm sorry.
Martha Schwartz. Further, under subsection E of 202.21, requires that any party to an action can, within 20 days of the filing of the note of issue and certificate of readiness, can make a motion to vacate it.
What about the interrogatories concerning the corporate structure? Were those responded to appropriately?
Yes, Your Honor, they were. The interrogatories relating to the ownership of 471 West 144th is owned by 471 West manager.
What about the disbursement of the sale proceeds?
Those were never specifically requested, either during the deposition or during the interrogatories. And
I'd like to move to another area.
yes, ma'am.
You know, what was the prejudice in ordering the additional discovery? You know, particularly since your clients did not maintain liability insurance, and certainly depleted the only asset during the pendency of the action. So, what's the prejudice here?
The prejudice here, Your Honor, is articulated in the precedent of Naftaliev, which instructs that once a case is certified ready, judicial discretion should be discreet, circumspect, prudent, and cautious.
What's the prejudice directly to your client?
That's the question.
Sorry, apologies. The prejudice here is both in direct relation to my client and to the non-party owner of one of the corporate defendants that has not been pled, has not been noticed, and frankly—
What's the prejudice, counsel?
Due to time and delay, Your Honor, precisely the prejudice the rules seek to avoid.
Time and delay. How is your client prejudiced? Your client sold its only asset, as my colleagues have mentioned, and apparently made a big profit. So time and delay, so what? They've got the money.
Well, respectfully, Your Honor, in these kinds of issues in real estate development, there was nothing that prevented my clients from dispersing with the property. That was the purpose of the formation.
But the whole issue, or one of the issues, was the corporate entity and perhaps piercing the corporate veil. And I thought that the court had made a determination that, despite what I think you responded to my colleagues' questions, that you had not, in fact, produced bank statements, whether the property had, in fact, was mortgaged and or the proceeds from the property sale.
Your Honor, the time for plaintiff, my friend over here, to request that information was during the discovery period. This action was filed nearly 10 years ago. The note of issue and certificate of readiness—
When did you sell the property? When was the property sold?
The property was sold in 2016, Your Honor, I believe. 2016 or 2017, it was.
But again, why would the additional deposition not be germane to those issues in terms of the corporate entity?
Because those issues relating to piercing the corporate veil were not pleaded, and as I'm sure Your Honors are fully aware, that the pleadings define the scope of discovery, and any kind of attempt to amend the pleadings at this point would be futile, specifically because of the delay. The fact of the matter is that the plaintiff had full opportunity to conduct discovery in this action. If the plaintiff was unhappy with the responses to the interrogatories, it had an opportunity to move to compel at that time or within 20 days of filing the note of issue.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Anthony DiStefano for plaintiff appellant.
Was that not an issue in terms of your pleadings, the corporate entity and piercing the corporate veil?
Is it not an issue?
Was it not an issue in your complaint and in this litigation?
It was not brought up until, frankly, we were before Judge Sokoloff at the pretrial conference. The fact that we were looking for information regarding where did the $2.3 million go from the sale of the property, because these are still ongoing entities, and theoretically, the money should be sitting in their bank account right now. And that's the purpose of asking for Mr. McGuire's deposition, was to find out what happened to the $2.3 million. That's when Judge
Sounds like
Sokoloff—
post-judgment discovery. Discovery in aid of enforcement of a judgment, but we don't have a judgment here.
Sure, Judge, which, the bottom line of all of this is, I don't know where we're going with this, because we're gonna have a trial, we're gonna get a verdict, we're probably gonna get multi-billion dollars in damages, and then we're gonna get the same deposition that we could have right now, or we could have actually had like 8 months ago when this was first ordered.
Well, counsel, what happened in the 65 months that this case was sitting dormant?
Nothing happened, Your Honor.
Well, I guess the question
That's
is,
the point. Why
was it?
Was it that nothing occurred during that period of time?
I can't speak for the attorney who was handling the file. I wasn't even with the firm during that period of time. I understand that.
Does that play into the calculus of like whether they're prejudiced, the fact that 65 months was allowed to go by and no discovery requests, no action whatsoever on the case?
Did they collect 65 months worth of interest? Well, the $2.3 million was sitting in the bank account. I don't see the prejudice. And as far as I can tell, it's my impression, and certainly Your Honors can correct me if I'm wrong, but Judge Sokoloff ordered a deposition, which is part of her ability as a trial judge to do, she was sitting in the pretrial part.
admittedly, but she still had the authority as a trial judge to order a deposition, and this court would review that for an abuse of discretion.
How do you
any
answer?
judge-
Go ahead.
How do you answer your friend's argument that the contours or scope of a pleading dictate the proper scope of discovery, and if there is no allegation in the complaint regarding piercing the corporate veil, then that isn't a proper subject for discovery?
Because it was information that was attained after the pleadings were drafted, number one, and number two, the question is again simply, where did the 2.3 million go?
And again,
We don't
that
even
goes
have
to
that.
my colleague's question to you, why is this just not post-judgment?
Exactly, Judge. But again, my point is we could have that deposition today, or we could have it after trial.
But then the question becomes whether it was proper for the judge to sui sponte order the deposition to be held.
Which is the second salient point, what Judge Sokoloff was doing here. Because Judge Sokoloff was sitting in the pretrial part, Your Honors are all familiar that that is in fact a settlement part. And Judge Sokoloff was trying to foster a settlement. And Judge Sokoloff believed that if we get the deposition of Mr. McGuire and he can answer where did the 2.3 million go, maybe we could have a resolution of this case without a need for a trial, without a need to have a second post-judgment enforcement action.
Thank you.
Thank you.
Just briefly, Your Honors, to Your Honor's point, the acceleration of post-judgment discovery into pre-judgment is improper because the condition precedent of a judgment has not yet been met. Further, the facilitation of easier settlement discussions is not a good reason for sua sponte reopening discovery on the eve of trial and delaying this action even further. I believe that all of my points on rebuttal have been made, but if there are any further questions, I'm happy to respond.
Thank you.
Thank you so much, Your Honors.
Last case for argument, Fishman v. Bunty and Yoti.
Thank you, Your Honor. I was sitting for a few hours without water, so. May it please the court. Alani Golansky for the plaintiffs, the Fishmans. We believe that on this record, the jury ought to have the opportunity to decide whether the city bears some responsibility for Mr. Fishman's horrific injuries that are initially tied to the city's decision to create faculty-only parking in the only area at which students could be dropped off at a school.
Did the city make that decision?
Yes, Your Honor. The city installed the parking and the parking signs, and the parking signs say no, only faculty parking, no parking otherwise.
Was that in response to a request by the school?
That is not determined in this record. What we know in this record from all the witnesses is that there's no faculty parking. There's no parking other than faculty parking and only faculty parking at the main entrance of Hunter. And the city continuously maintained those signs from the beginning, 1975, at least until through the time of the injury, 2012, continually maintained the signs.
Didn't Mr. Joseph Farina, DOT engineer, say that a school must request a drop-off or pickup zone in order for that designation to take place?
Yes, but we know from all of the evidence here that the city initiates its own inspections, it has inspectors, it initiates its own signage, and that statement is really a statement of the city's practice.
Okay, so to that point, is there anything in the record that suggests that the street was not reasonably safe? Is there anything in the record that there were any complaints to the city, that the city received any complaints concerning that the street was unreasonably safe, was not reasonably safe?
There are no complaints about in the record about the double parking hazard, but it's immediately necessary that there will be a double parking hazard, and a double
So
park.
under that theory, then, are you suggesting that the city would have an obligation and a burden to go through every street where there is a school to ensure that there are, or to ensure that there are no issues in terms of double parking?
I understand that question, but once the city affirmatively takes the action of closing off all parking,
But was the reason that the city closed, quote unquote, closed off all parking and designated parking for the faculty, was that because of an issue as to the safety of the street, or simply because that is what is done in front of every school that I know of, and from the public schools, and to some extent in front of private schools, there is faculty parking, especially in front of public schools?
that is not in this record.
But the point is, my question is, again, what is the relationship between setting aside parking for faculty and the unreasonableness of the street itself? What's the relationship?
The relationship is that if you take the only practicable area for dropping off students, whether a parent is driving or a livery driver is driving, and you take the only possible area, knowing that students are going to be driven to school, and you fill that up with earlier arriving faculty parking, you're creating a double parking hazard.
And so that goes to my colleague's question to you. Was the city responsible for this, or was Hunter responsible for this in terms of requesting that there be designated street parking for faculty?
We don't know we don't know who requested these particular signs, but we know that the city installed, maintained, and
Okay,
knew
so
about
then
it.
the question becomes, was there an obligation on the city to, to possibly deny the request of Hunter based upon the street? And then that goes back to whether or not there's a question in terms of the reasonableness of the safety of the street.
Well, perhaps I can simplify the issue, which is apart from these substantive questions, the city, in making this motion, had a burden, and the cases show the city had a burden first to show that the street was safe with the signage. They had an initial burden to do that, and that's the Serio case, which
And how did they not meet that burden? Now, that was my question in terms of complaints. Are there any complaints concerning the street not being safe?
That is not, I believe, respectfully, what it would take to show that the street is safe. You need an expert to come in and say, yes, there's double parking, but on this street, it's still going to be safe. They had no expert witness to say that. They did not have any proof that the hazard increased over time, which means that as soon as the signs are installed, there's a hazard that's created. They didn't meet that burden, and they met no burden in showing that the city played no role in creating this double parking hazard. They met no burden in showing that the taxi driver's conduct or Mr. Fishman's decision to go behind the car was the sole proximate cause here, and they met no burden by producing, what should have been an expert testimony.
Well, they don't have to, on causation, they don't have to show sole proximate cause, right? I mean, they could, not saying specifically in this case, but that is one way of defeating as a matter of law if you're a defendant, a proximate cause argument by the plaintiff. Wasn't one of their arguments as well that any negligence on their part in placing that sign where it was, or creating this environment for this type of accident, was merely furnished the occasion for the accident? Yes. The grievous injuries here were a function of the decisions and acts of a number of people who the city has no control over. So other teachers and parents decided to park there, and a cab happened to drive by, and for whatever reason, the cab driver either didn't see Mr. Fishman or he lost control. These are all actors over whom the city has no control.
Yes. That defense is controlled by the standard announced by the Court of Appeals in the Durian case, which the city itself cites. It gives the standard. merely furnishing the occasion is the same standard as whether there was an intervening act that was unforeseeable or whether the injuries that occurred were not the same in kind. And here, there were no intervening acts that were unforeseeable, because double parking is totally foreseeable, and the injuries are exactly what you'd expect from a double parking hazard.
Justice Weber, may I ask a very brief question? Thank you. So, counsel, let's assume that the city established its prima facie case for summary judgment. My question to you is, what issue of fact did you raise as perhaps the roadway was not reasonably safe, there were prior complaints, prior similar accidents, or even, that a further study, traffic study was warranted. Did you do anything like that to raise an issue of fact?
Well, yes, we had an expert witness who testified that this was an unnecessary signage creating a double parking hazard. There's no basis for it in the logic or from the point of view of safety. It was a proximate cause, which is a factual issue. We had the expert, they had no expert, and our expert sufficed to create a question of fact, as well as the witnesses' experts who showed that the city continually inspected, maintained the streets, was responsible for the street safety here. And I understand the point that there were not necessarily any prior accidents such as this one, but let's say you have a pothole, a dangerous pothole, and it's there for a number of years. That doesn't render the pothole safe.
No, but we have a pothole brigade, and we also have citizens and motorists who will immediately report the pothole to the city. But you do have time on rebuttal.
Thank you, Your Honor.
May it please the court, Jeremy Schwader for the city respondents. Plaintiff's theory of the case is that the city can be held liable for failing to create a designated curbside parking area for vehicle passengers in front of any highly trafficked building in the city.
Well, that's what it appears to be, but it also appears that the designated faculty parking took away from the ability to have a designated drop-off, or that you should have had both.
That's going to be the case for parking on any street in the city, that the city has designated it for some use, whether it's for metered parking, public parking, police parking, fire parking, teacher parking.
Judge parking.
Right. Their theory is that in every case, the city is going to be liable if it hasn't undertaken a study to determine that designation on every block of the city in front of an area where we can expect people to be dropped off by cars, or they're going to be liable for anything that happens. And that
Does
is
the plaintiff have to show notice here, or can he avoid the notice inquiry altogether by placing this sign there, the city, quote unquote, created the hazardous condition?
Not when you're talking about a sign that has been there for 50 years.
Well, that was the other thing. Hunter's been around for a very long time. I don't know how long that signage has been there. But does the city have to show, or does there have to be something in the record to talk about that in terms of how long that signage has been up, how long the signage has been up for public schools in the city? Yes.
So we know that this sign was, this area was designated 50 years ago. And what the city showed is that there has been no notice in that time of any accidents, any indication that there is a double parking hazard on 94th Street. And let's remember why that is the case. Because 94th Street is not the drop-off zone for this school. The principal testified that 95th Street was the vehicle drop-off zone. So the city, it's not going to, there's probably not going to be any notice that comes out of 94th Street, but the city is never going to be on constructive notice that there's suddenly going to be parents illegally double parking at an area that isn't the designated drop-off zone. So
I understood your friend correctly. He said that by placing the sign there, it was imminently foreseeable that these double parking conditions would manifest themselves and create an environment ripe for accidents. Maybe not, foreseeable of the precise accident here, but accidents of this type?
Couple answers to that. First of all, so that's going to apply to parking anywhere in the city for every building. This building, any building where people are going to be dropped off by cars. It doesn't matter that it's a school here. His theory is that anytime the city designates any sort of curbside parking that isn't a vehicle drop-off area, the city can be held responsible. Second thing on that is the record clearly shows this is not the designated drop-off area. My friend here is really misrepresenting the record when he says that this is the known area, the exclusive area. That is
There is
not
an entrance on 94th.
absolutely there's an
There's
entrance
an
on
entrance
94th.
on 94th, and there's an entrance on 95.
Right, and the principal, the only testimony we have here is that the school puts school safety officers on 95th Street, puts staff on 95th Street. The very point of that is to help elementary school students who are being dropped off by vehicles to help them into the school. That's not what you have at 94th Street. Plaintiff was aware. He says he doesn't know where the right drop-off area was, but
Right,
he
I think
knew
he
that
said
90.
his wife normally dropped off or something. he
They
doesn't know.
both did it. I think they both
did.
regularly use 94th. They said they had never been told where to go by the school. They knew that 95th was where the school safety officers were. So, I mean, all this really only goes to, is the city on notice, right? So the city this is what the case law has. Serio, Diacate, many other cases we've cited.
Did
you have to
meet your burden? I mean, your friend states that you did not present an expert, and there should have been some type of expert testimony in support of your application.
The only thing we need to show in a negligent roadway design case is lack of notice that there is a roadway design defect that needs to be studied or changed. We definitely met that burden because we showed that there were no incidents of accidents that would have put us on notice, no complaints, nothing, and particularly when you're talking about an area that isn't the drop-off part for the school, and not a city school either, right? So the record clearly reflects, and this is another misstatement by my friend here, the city does not have a duty and does not go around looking at schools to see who could use a drop-off zone, particularly non-city controlled schools. It's another misstatement of the record here. So we know from the record that the only time a drop-off area is going to be put into any school is if a school requests it. We know that the school did not request it here, and they particularly did not request it for an area that is not their designated drop-off area. So, yeah.
Thank you, Your Honor. Double parking is not like a pothole. I understand.
Double parking is also not legal in a lot of cases, am I right?
Double parking is not legal. It's a hazard. It's an inherent hazard as a matter of law. But at the same time, it's not the sort of hazard that's like a pothole where people are going to report that and complain about it necessarily, because people double park all over the city. But if the city creates signage which facilitates and necessarily requires double parking at the main entrance of a school.
Signage in order for there to be double parking. I mean, no, the signage is you park by the curb. That's the signage, and then folks are still going to double park.
No, well, the idea is, they bring the hotel analogy up. Let's say at the hotel main entrance where people arrive with their bags and stuff, let's say the city put up signs there saying only hotel employees can park here, and the hotel employees get
It says hotel loading zone, and people still double park.
Well, they might still double park, but if the city creates the hazard, the city should bear some accountability for not thinking about what they're doing and negligently creating this hazard. The 95th Street availability is a total red herring. That was not a practicable drop-off. The main entrance is 94th Street. The city's website memorializes the practice. It says from every direction, you go to 94th Street, and that's your last move, and that's how you drive in, no matter where you're coming from, and you drop off at 9, and it doesn't use the word drop off, but it says...
The city says that?
No, Hunter, the school does, but it publicizes this to the world.
But the Hunter is not the city.
Hunter is not the city, but this is notice. The city knows this is the main entrance. It knows that's where you drop off students. It's negligent in taking all the available parking and giving it to the school.
Thank you. Thank you,
Thank you, Your
both.
Honor.
Thank you.